management prerogative, generally speaking, is viewed as managers and employers having direct control and control over their business. And this control is unhindered by workers. That's a general definition of management prerogative. This, in my view, is circumscribed by the law of whichever country the organization operates. Since the pandemic, what we have been seeing in court is that, and we have received a number of IROs, which is industrial relations offenses, as a result of that, is that management is altering terms and conditions of employment without any consultation with unions or without having conversations with workers. And this is what we call in industrial relations the unilateral alteration of terms and conditions of employment. This has caused a floodgate of litigation in court by several unions throughout Trinidad and Tobago in an effort for the court to rule as to whether the employer can have that type of control and prerogative without consultation or notice to unions. Well, one of the things I said in my book is now more than ever is the time for all parties to practice good industrial relations and adhere to the principles and practice of good industrial relations and international labor standards, because this is the time more than ever. We have to think about life after the pandemic, and we do not want after the pandemic that there be very ad hoc, very systems which are not effective, which are ineffective, and which have developed due to a non-adherence to the laws of Trinidad and Tobago and the wider Caribbean. Now, in my view, because there is a pandemic, states, governments throughout the world have intervened, and they have intervened in a way in where some of the rights in some countries have been put aside in order to protect citizens. So one has to be very careful when you are having that balance to ensure that rights and freedoms continue and are adhered to by everyone. It cannot be that an employer would be allowed to, to abuse the fact that there is a pandemic and to violate and breach all the fundamental principles and all the laws related to the labor market and use the pandemic as an excuse. It could only be that all the parties, the social partners, come together, adhere to the rules and the principles and practice, and have ongoing conversations as to how do we move and how do we think outside the box to move from what existed before, and how do we shape something which may be new, or we shape something which may work only for this period, or we shape something which will be the new normal going forward. So as you move to shape modalities of work, and you have new modalities of work, it could only be that all hands are on board. It cannot be that employers use management prerogative and say, it's my prerogative to do so and so. Because at the end of the day, they all, employees, employers, and unions to a smaller extent, but the employers and the employees have a vested interest in securing and ensuring that this company is successful. The state, I said in the opening of the law term last year, that in my view, some of the measures which have been enforced by the state and when I say the state, I mean Trinidad and Tobago, and some of the measures that I have read which have been enforced in other countries, particularly in the Caribbean, those measures were necessary. It has affected a large part and it has impacted directly on the business community. I think that there's a need for balance and there's a need for dialogue again, and this time tripartite dialogue between the state, the workers and the employers and the unions. The state, the employers and the union, because this is time for tripartism. It might be now that in that tripartite discussion, the state may now be made to know that there are different ways you can approach the same problem based on what the unions and the employers might be saying. Or it might be that the unions and the employers may now understand from the state's vantage point. But to me, this is the time for tripartite discussions. I know that we have a tripartite council. I can't remember the exact name of it. But I do not know how this council has been functioning. But this is the time for tripartism, because business owners have invested a lot in terms of their businesses, and they would want to reap the rewards and the profit from their businesses. And I think the COVID pandemic has affected the medium and small businesses more than it has affected the big businesses. The medium and small business owners need to know that despite the fact, and they have to take emergency measures, as you have said, to close down, they still need to find a day, an hour, a week, a minute to have discussions and consultations. If there is no union, they need to speak to their staff. It must not be that you get up in the morning and you report to work and the business is closed. I mean, take it from the human point of view. And if you don't want to look at the industrial relations point of view, labor is directly embedded in the socio-economic lives of people. So if you were to take out the economic impact, the social impact of someone who has worked with you for months, for years, and they have assisted in developing your business. Some lawyers argue that they have a right to property in your business. You will not call them aside and say, listen, due to the restrictions which have been imposed by the government, this is my position on it. They may not agree, but at least you had the discussion. And I think it is very important, especially in this time as it relates to the labor market, for there to be tripartism. It cannot be decisions being made by any one of the social partners independently, but it must be that coming together and meeting and discussing, because there's life beyond COVID. And if you break it up now, what are you going to restore after?